is the precise type of hindsight analysis the Supreme Court warns against, frequently imposing on officers who in their daily work are engaged in tense, uncertain, and rapidly evolving situations. If you have no more questions for me, I yield my remaining time and I thank you. Thank you, counsel.
Good afternoon, and may it please the court. My name is Alex Lindvall, and I represent the City of Mesa police officers, in this case, Officers Pew and Rosema. My primary concern today is to make sure I address any lingering questions the panel might have, and because my time is so limited, I invite you to interrupt me with questions, and please let me know if there's a specific area or issue that you'd like me to focus on. With that being said, I want to emphasize that there are no genuine issues of material fact in this case. The plaintiff, while he was, and to use his own words, out of it on meth and hallucinogenic drugs, physically fought 3 police officers and resisted arrest for roughly 3.5 minutes to avoid being arrested for a serious felony. This is all undisputed.
I agree with the answer to the question that I asked your opposing counsel as to what point in the episode the handcuffs were placed on. She gave a very precise answer that it's 46 seconds into video D. Do you have a different view of that or no?
It's difficult to tell. I think you can, at that 46-second mark, I think it's fair to say that at least one clasp was on the plaintiff's wrist, but they were also administering leg shackles and they were still trying to get it onto another wrist. It's difficult to tell from the video exactly when the handcuffs came on, but I don't think it precisely matters exactly when those handcuffs came on because the plaintiff was resisting arrest through the entirety of the sale.
Well, but it makes a big, once someone has 2 handcuffs on their back, they're a lot less dangerous, and the level of force that can be used that could permissibly use goes down. So that seems to be an important issue. And so I wanted to get very clearly your position on what the record shows a reasonable trier of fact could find as to when the handcuffs were on both hands.
Understood, and I agree that that is an important turning point in this interaction. But I think for the purposes of this appeal and where we're at in the procedural posture of this case, I'm okay with this court assuming that the handcuffs were on the plaintiff at that 46-second mark. I'm not sure, like the 46-second mark, I don't think that's 46 seconds into the entire encounter. It's just where that was on a particular video. This was minutes into a long, prolonged physical fight. It's not 46 seconds out of the 3.5 minutes.
So your position is not earlier than that, but it might have been later that it got on, but...
Correct.
Okay.
So if that's the case, couldn't a reasonable jury looking at from the 46-second and video D on find that the officer's use of force beyond that was excessive? He was lying on the ground, he was restrained, he wasn't armed, he was immobilized. So why doesn't that get to the jury?
Well, 2 reasons. One, I don't think a jury could find that that's excessive because he was still actively, I understand that once you're in handcuffs, it's much harder to offer extreme resistance or to physically fight an officer, but he was still squirming around, wiggling, trying to get up. He was out of it on drugs. I'm not sure if he was trying to run away or anything. The officers were just trying to keep him in a spot where they could actually wrangle him. So I don't think that's going to amount to excessive force under anything, but more importantly, I don't see any clearly established law that would say that what the officers did there was unreasonable. And if there's no clearly established law, then there's no reason to give this case to a jury at all.
Well, what's your response to their argument that after the handcuffs are on, Pew has his knee on the back for more than a minute and causes injury from that, and Lalonde says that knee on the back, to such a degree as to cause injury is bad? Why isn't Lalonde squarely controlling?
Yeah, I think describing the holding of Lalonde in that way describes it at a much too high level of generality. I think we need to look at the specific facts of Lalonde and see if they are on all fours with this case, and I think they're clearly not. I went through in my brief in detail, so I won't belabor the point, but just to real quick. 1, the suspect in Lalonde was rational and sober. The plaintiff in this case was out of it on drugs. 2nd, the suspect in Lalonde was not resisting when the officers used force. Here, the plaintiff was actively resisting for a prolonged period of time. 3rd, the suspect in Lalonde was suspected of only a minor crime, while the plaintiff in this case was being arrested for aggravated assault. 4, the seizure in Lalonde took place in the suspect's home, but the seizure in this case took place during a traffic stop, which are especially fraught with danger for police officers. And it's important to remember that in this case, Once the plaintiff started this altercation, the officers had to turn their back to the driver of the vehicle that they were there. And they didn't know if this person, they knew that the driver of the vehicle had a criminal record, an arrest warrant, and they planned on arresting him during this, but they had to divert their attention to the plaintiff, who was essentially going berserk on the side of the road. And the fact that there was someone behind him that could have been on drugs, could have been armed.
But when shall is there and shall's at the door, then that's not a factor.
Correct.
Anymore.
Yeah, I agree with that.
And that the force was administered beyond that, right? Subsequent to Deputy Shaw's arrival and guarding of the driver?
Yes, that's correct. It's just before those sheriff's deputies got there, the circumstances were a little more dire because they couldn't see the driver. That's what I'm trying to.
Let me ask you about some of the specific acts of violence, because before the point at which he's handcuffed, they're entitled under the law to use a substantial amount of force to bring him into compliance for arrest, and that includes getting him handcuffed. That's the force necessary to get him handcuffed is going to be reasonable. Mm-hmm. But some of the uses of force don't seem to have any relationship to accomplishing the task of getting him in handcuffs. How does taking his head and smashing it into the ground 4 times succeed in advancing getting him into handcuffs? I don't understand that.
Right. Well, the officers didn't just start out with the significant uses of force like this. They were starting out slow. They tried to arrest him with the normal means, and they slowly escalated their force. But they're escalating levels of force.
I don't think it was slow. That was pretty fast escalation.
I mean, it's a 3.5 minutes. That might not sound like a particularly long period of time when you just read it on paper, but 3.5 minutes when you're actively wrestling, a run amok drug abuser is an eternity. So, I mean, they didn't just start with bashing his head into the ground. They tried a taser. They tried a few fist strikes. They tried a few other things, but this didn't seem to have any effect on the plaintiff.
Let me ask you a question about the taser, because what he's saying is that there are triable questions of fact here because the taser is actually causing the involuntary movements. Is that, wouldn't a trained officer know that and account for that?
No, and I don't believe that's a genuinely disputed issue. In this case, you can clearly see in the video that he's getting up to his feet with officers on top of him. He's actively resisting arrest. He gets up to his knees. He almost gets on his feet at one point. He's not doing weird involuntary actions that you would expect to see from a taser. He was actively resisting in this case, and he was fueled by meth and DMT. And that every single piece of evidence in this case points to the conclusion that he was actively resisting and that these normal pain compliance techniques were having no effect on him.
Going back to Judge Collins' questions about, smashing his head on the ground. I mean, when that happened, you had Officer Macklin or Deputy Macklin on top of him, so he couldn't move. You had 2 other officers, and these are, you look at the video, they're very big guys, very strong guys. I mean, was it really necessary to bash his head on the ground there? I mean, this is not a situation, it's 1-on-1 officer, or even 2-on-1. I mean, there are 3 guys, including one who was sitting on top of him.
Mm-hmm. Yeah, I understand. And that's maybe a fair critique if you're sitting in the comfort of the judge's chambers. But in the moment, the officers were in a very chaotic, very stressful, very time-sensitive, tense, uncertain, rapidly evolving situation. Maybe not. Maybe he shouldn't have bonked his head. Maybe it was appropriate in the circumstance. But I'd like to just end really quickly, if I may. Right now I'm over time, but I'd like to end with a quote, if that's okay, that I think is really appropriate for this case.
No, go ahead and fully answer the question.
Yeah, and this quote is, I think, a good answer to the question. "We are generally loath to second-guess officers' actions in a dangerous situation by analyzing each act without looking at the entire event and considering the officer's mindset amid the uncertainty and chaos. We should not scrutinize an officer's every minor move in a frantic and chaotic situation as if we were examining the Zapruder film in slow motion." And that's from Hyde versus City of Wilcox from last year. I think that is an appropriate quote for how to analyze this case. You can go through and maybe look at markers 33 through 44. They did this, this, and this. Maybe that's excessive force, maybe it's not. But that's kind of missing the bigger picture here. These officers were tasked with wrangling a frenzied drug abuser. This is a prototypical nightmare scenario for the police, and this court should give them considerable leeway.
All right, thank you, counsel, for your argument.
Thank you, Your Honors. My name is H.R. Fitzmaurice, and I'm here on behalf of Cole Spencer. Excuse me. First, I'd like to reiterate that there are disputes of fact in this case. In fact, whether or not Spencer was on drugs is actually disputed. Spencer has been consistent from the beginning that he was not on drugs. Secondly, I'd like to say Lalonde does squarely govern this case. There is clearly there's a clear factual analogy between the two.
I go back on that first one. What does the record show about what the officers said that they believed at the time of the incident about whether or not he was on drugs?
Yes, in Officer Pew's opening or his report, he states that he believes that Spencer was either on drugs, or that he was planning on resisting, or that he was planning on running, or that he was planning on making bad decisions. He nowhere says that he objectively has evidence that Spencer is on drugs.
So there's nothing in the contemporaneous record that would objectively reveal the use of drugs or...
Not from the facts in the light most favorable to Mr. Spencer. Okay. So, as I was saying, Lalonde does squarely govern this case. Mr. Spencer was unarmed. Lalonde was unarmed. There was never even a question of whether he was armed. Lalonde initially resisted. He admitted to initially resisting. And as we've discussed, it's hard to dispute that initial resistance was a factor. But the court ruled after he was subdued and handcuffed that kneeling on his back in such a way that could cause and did cause significant injury was a violation of his Fourth Amendment rights. We have the same situation here. Kneeling on somebody's back and neck for over a minute is clearly established to be a constitutional violation, and it did cause severe injury. And if there are no further questions, I will rest, but I'm happy to answer any questions you may have.
All right, thank you very much to both sides for your very helpful arguments today. The matter is submitted, and thank you.
Thank you.
NUW Law Clinic for taking this case pro bono. We appreciate it.